Welcome back to Chris Price's Real Estate Masterclass. Coming to you today from Yarra Ranges Lawyers here at 16 Wynyard Drive in Mooroolbark. Today I welcome Christy Burrows. Welcome, Christy.
Thanks, Chris. Thanks for having me.
Your role in the business is?
So I'm Director of Yarra Ranges Lawyers. The practice has been here for coming up 4 years now. I've been practicing law for 14 years, but decided to take the plunge and go out on my own about 3.5 years ago. So here we are.
Beautiful. Christy, we're meeting with you today, and there's a lot of different legal aspects with property that people don't or aren't aware of, especially with wills. Your advice with preparing wills, what people need to be aware of with wills?
Sure. So I guess the first thing I'd like to talk about is what happens if you don't have a will. That can have some unintended consequences. If you don't have a will, if you pass away without a will, then the law dictates where your assets go and what happens to your property, and that may not be what you'd like to happen. So it is important to have a will so that your wishes are carried out, particularly in relation to your property and your assets. If you pass away without a will, it depends on the size of your estate and also your family structure. So whether you have children, whether you've got a partner or a spouse, the law determines where those assets go, and it's not always to the people that you'd like to provide for. So it's important to have that in place.
How does the manner of holding property affect your will?
Sure. So there's a number of ways that you can own a property. Firstly is as a sole proprietor. So if you purchase a property just in your sole name, then that will actually pass under your will. So that's your asset, that forms part of your estate when you die, and you can gift that under your will. As a joint proprietor, so a lot of people, husband and wife, quite often will purchase their property jointly as joint proprietors. That doesn't automatically pass under your will when you pass away. It goes automatically to the surviving spouse. So if husband passes away, it passes to the wife and vice versa. And it's only once the surviving spouse has passed away, then will pass under their will. So that's probably the most common way of holding property. But there's also tenants in common. You can hold a property as a tenants in common, which can be 50-50, or it can be an unequal portion. So if property is being invested, it might be 30-70% ownership, and that share of the property transfers under your will. You can gift that under your will. It doesn't automatically transfer to the other person if you pass away.
With tenants in common, we get a lot of broken families.
Yes.
That in time actually come back together again. Yep. New partners have families. Tenants in common, how does that affect the process in time if there is an issue down the track? Sure.
So what we find a lot with families is they're purchasing properties as joint proprietors, but they might have children from a previous relationship, and they want to make sure that those children are provided for under their will when they pass away. So if you own a property as a joint proprietor, ultimately you cannot, if you pass away first, you cannot provide for your children in respect of that property. What you have to do is hold that property as a tenant in common with your new partner to enable you to determine what happens to your half share of the property once you pass away, and to ultimately let your children have the benefit. So you can, in your will, allow your partner to still have the right to live in the property, and they have what's called a life interest in the property, so they can live there for as long as they want. They have a roof over their head, but the legal ownership of your half share doesn't transfer to them. It reverts back to your children when that life interest comes to an end. So that's a very common way of benefiting both your new partner, but also your children from a previous relationship. But you have to hold the property as tenants in common to do that. So we find a lot of people have their property as joint proprietors, but they have to change that to tenants in common to be able to achieve what they want.
Property in trusts, how does that work?
Yes. So properties that are held in trust, so whether it's a unit trust or a family trust, quite often properties are purchased in that manner for tax reasons and for asset protection as well, to keep an asset protected from any liability or claims. Ultimately, that property doesn't pass under your will because it's not owned by you, it's owned by a trust. So what you can do though in your will is you can actually determine who takes control of your trust when you pass away. So you're not transferring the ownership of the property, you're just transferring the control of the trust to the beneficiaries or spouse or children.
property held in self-managed super funds.
Yes, so very similar to trusts in the sense that it's not able to be gifted under your will because it's not your asset. But again, you can nominate who the beneficiaries of your self-managed super fund are, and ultimately they'll receive the benefit of the property that's owned by the super fund. It can't pass under the will. Yeah. So when we're dealing with wills and self-managed super funds, we always check to make sure you have made a binding nomination with your super fund so that you have nominated a beneficiary or beneficiaries of your fund who will benefit from the assets upon your death. Yeah.
With the sale of properties and managing sort of throughout really difficult times, power of attorney comes into play, and we see a lot where powers of attorney believe that when a person passes away that they become executors. Doesn't work that way, does it?
No, not always. Commonly, the person that's been nominated as appointed as an attorney is quite often the same person as the executor under the will, but not always. And what we find a lot is that people don't actually have a power of attorney. So a lot of people assume that husband and wife situation, if one becomes unwell, loses capacity, that the other automatically has that right to do things for them and sign, but that's not the case. And particularly with property, if the property's in two names, then you have to actually have authority to sign a contract or sell a property or buy a property for somebody that doesn't have that capacity. So it's important that you have a power of attorney that gives somebody, or more than one person, the authority to step into your shoes and sign a contract to sell a property, because it's not automatically your next of kin. So powers of attorney are really important in that situation.
Moving forward, as to your general rule of thumb, assisting with wills, titles, trusts, self-managed super funds, legal advice, it really pays to actually sit down and talk to you. Just as a guide, sort of everybody says, oh, it's expensive to use a lawyer. Any sort of a price guide, or how does it work, sort of with your services on that side of it?
Sure. So we have a fixed fee scheduled for wills, powers of attorney, estate planning. So depending on if it's just a single person or husband and wife or partners, we have package costs as well if you're doing everything, wills and powers of attorney. Or if you're just wanting some advice, certainly we can sit down with you and give some preliminary advice, then with a view to getting some documents prepared for you. But all fixed price, so you're given that up front and there's no scary surprises down the track.
Christy, how do we find you? How do we contact you?
Sure. So we have got a website, which is yarrarangeslawyers.com.au. All of our details are on there. Or you can phone 9727 4055. Email admin@yrlawyers.com.au.
Christy, thank you for your time.
Thanks for having me.
And thank you for watching, and we look forward to seeing you next time.